Hello, Michigan Realtors, and welcome to the Letter of the Law. Today we're going to discuss some of the common misunderstandings centered around the Seller Disclosure Act. Now, we receive a number of questions on seller's disclosure, and we thought a solid top 10 would be a great opportunity to explore some of the most common traps. Number 1, the fact that sellers have never lived in a home does not mean that they are exempt from filling out the seller's disclosure form. Sellers who have not lived in the home cannot state that they know nothing about the condition of the home, unless that is, in fact, true. Now, most sellers know something about the condition of the home, even if they have never lived there. If, for example, the sellers know that a basement leaks, it is fraudulent not to say it does not. It is fraudulent to say that the sellers know nothing about the condition of the home because they have never lived there. Further, it is fraudulent to accidentally skip the question that asks about water in the basement. 2, a listing agent should never advise a seller against making a disclosure on the seller's disclosure form. Disclosure is always the safest course of action, and realtors do not want to put themselves in the position of having their sellers testify that the sellers wanted to disclose a particular defect, but that their realtor talked them out of it. 3, most of the questions on the seller's disclosure form relate to the present condition of the property only. One notable exception is the question on whether there has ever been water in the basement or crawl space. Now, it has been held that sellers were required to disclose the fact that the basement leaked 26 years ago. Other examples of historical questions include major damage to the property from fire, wind, floods, or landslides, and any structural modifications, alterations, or repairs made without necessary permits or licensed contractors. Number 4, a seller is not responsible for an innocent misrepresentation in a seller's disclosure form. The form says, "This statement is not a warranty of any kind by the seller or any agent representing the seller in this transaction, and is not a substitute for any inspections or warranties the buyer may wish to obtain." Now, the seller's protection against liability for an innocent misrepresentation is limited to the questions on the seller's disclosure form. Under Michigan law, generally, sellers are not required to volunteer information, but if they do, they are responsible for false statements, even if innocently put forth. Now, when the Seller's Disclosure Act passed, it was decided that for the first time, sellers were going to be required to volunteer certain information, but in exchange, the law would protect them if they were simply mistaken. Number 5, sellers are not obligated to conduct any research as to the condition of their home. The form says, unless otherwise advised, the seller does not possess any expertise related to the construction or condition of the home. Unless otherwise advised, the seller has not conducted any inspections of generally inaccessible areas to determine the condition of the home. Number 6, there is no private cause of action under the Seller's Disclosure Act. Under the Seller Disclosure Act, if the seller fails to provide the buyer with a seller's disclosure statement, the buyer can exercise his or her right to terminate the purchase agreement at any time up to the date of closing. Now, a seller could decide that they are willing to risk the fact that the buyer may walk from the transaction at any time and simply refuse to provide a seller's disclosure form. And there may be a reasonable basis for this choice. For example, a home being sold by someone who has a power of attorney for a legally incompetent or incapacitated seller. However, a buyer who has been provided with a partially completed form could argue that the seller has not actually complied with the Seller's Disclosure Act, and therefore the buyer can still terminate the agreement. Number 7, a buyer may have a common law fraud claim based on a knowingly false statement made by the seller in the seller's disclosure form. If a seller does disclose the existence of a problem in the seller's disclosure form, courts have generally held that the burden shifts to the buyer to investigate the nature and extent of the problem. As a general rule, Michigan courts don't seem to be open to the argument that the seller was required to provide more detail than they did, particularly if the buyer made no follow-up inquiry. Number 8, The Seller's Disclosure Act has been amended to make clear that any representation as to the condition of an appliance in the seller's disclosure form does not mean that such an appliance will necessarily be included in the sale. The purchase agreement will be controlling. Buyer's agents should make certain that the buyers understand this limitation, and the same is true with items mentioned in the MLS. Avoid disputes by specifically listing all personal property the buyer wants included in the offer to purchase. Number 9. The seller's disclosure form is required for the transfer of 4 residential units or less. The Seller's Disclosure Act form is not required for commercial transactions or for sales of vacant land. Now, there are vacant land disclosure forms out there, but unlike with the Seller's Disclosure Act, a seller will be liable for an innocent misrepresentation in a vacant land disclosure form because there is no statutory protection like there is with the Seller's Disclosure Act. Number 10, and finally, a seller is statutorily obligated to update the seller's disclosure form if something occurs after the form is completed but before closing. That makes the statement inaccurate only if such inaccuracy relates to the structural, mechanical, or appliance systems. The statute also says if information disclosed becomes inaccurate as a result of any action, occurrence, or agreement after the delivery of the required disclosure, the resulting inaccuracy does not constitute a violation of this act. Seller makes these disclosures based on the seller's knowledge at the signing of the document, and seller certifies that the information in the statement is true and correct to the best of the seller's knowledge as of the date of the seller's signature. Just because the seller is not statutorily obligated to update the seller's disclosure form, that doesn't mean it isn't a good idea. Suppose at the time the seller fills out the seller's disclosure form, there has never been any evidence of water in the basement. 3 weeks later, the basement leaks. Does the seller really want to get involved in a factual dispute over what they knew when? Again, the listing agent should not advise the seller against updating the form. If the listing agent does advise the seller not to update the form and a dispute arises after closing, the seller is likely to point to the listing agent. And that's a wrap. I hope you enjoyed this segment of Letter of the Law. We look forward to hearing your feedback and also suggestions for future installments. Until that time, please have a great and wonderful fall season, and we'll see you next time.